Rebuttal?
I think that before we even can discuss selections, arrangements, elements, we have to ask the predicate question: what are we comparing? Are we comparing the composition embodied in the album recording, or are we comparing a deposit copy lead sheet, which you know is inaccurate and is prejudicial, not the defendants, but the plaintiff?
You didn't really argue a selection arrangement theory at trial, did you?
Absolutely, we did. And to say otherwise is false and misleading to this court.
I didn't see an argument that there were unprotected elements which were used and selected and arranged in a particular way, which is the selection and arrangement theory. Your theory was it was a direct infringement, right?
No, we had a selections and arrangement instruction. We also had combinations of unprotectable elements, Swirsky. We also had that it was used in a memorable and creative way. We also had...
Do you see the combination as distinct from the selection argument?
I think it's virtually one of the same, and the question really comes down to originality. And
Because the phrases are thrown about. You didn't argue selection. You argued combination.
Combinations of unprotectable elements
Correct.
Can be protectable if used in the original
and
way.
Do you view that as synonymous with selection and arrangement as used in the copyright law?
Yes, we do, and I think that was clear through the transcripts at trial.
And let me ask you then,
Yes.
do you think that what you're arguing qualifies as a compilation as it's set out in Section 101?
I don't see it as a compilation. I see it more of a combination of unprotectable elements. But let me take it further. What does that mean?
Do you agree with what the government said, assuming that the issue of selection and arrangement was properly preserved? Do you agree with what the government stated, that the smaller the range of available creative choices, the thinner the copyright protection should be?
Let me go right there. 2 notes are protectable. Think about the greatest composer of score.
Can you give me a yes or no answer, and then you can give examples of it?
I'm sorry. I believe that...
The government correct? Do you have any quarrel with their proposition that the smaller the range of available creative choices, the thinner the protection?
That's absolutely false. You can have 2 notes and they're protectable, and I'll give you a perfect example. John Williams, Jaws. Dun-dun, 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 dun-dun. It's one of the most defined, one of the most recognizable pieces of music. It's offered protection. Everyone recognizes that Jaws is as much about the music as it is about the movie. And that's so distinct and it's so creative.
Is it the 2 notes that's protectable, or the 2 notes repeated?
Well, here's what we say. We can break things down to the is TH and E. We can break things down to the most minimal parts. The question is there the modicum of creativity? And what is that, however small? It doesn't mean we have to have descending chromatic scales and pitches and notes and this. It's not the magnitude of how many different elements. It's how creative it is.
But it doesn't, to have 2 notes, I mean, Jaws may be not your best example, because to have 2 notes, your position is because they're memorable, therefore they enjoy some sort of heightened copyright status?
No, it's not. It's not dependent on the number of elements. It's basically looking at the creativity. And what is the creativity? It's if it's original. Original means not copied, and it has some modicum of creativity.
Well, as I read your argument, I read your closing several times, and I read, of course, the other closing, and I read all your argument at trial. And it seemed to me that your focus was on the original parts of this, not on some combination. And you talked about what makes it unique, and then you laid out all of those things. That's an originality argument, correct?
Originality, it's an originality, also a combinations or selections and arrangements argument, because...
It's not. I mean, that's the problem with it, is you never made that argument. You kept talking about what makes it unique is such and such, and then later you went on in reply to the amicus briefs and said, well, this could be bolstered by what is also selection and arrangement. But I understood one of your stronger arguments was what you considered to be, as you put it, the unique and original aspects of the song. Is that not correct?
I believe that we did make a selections and arrangement argument. I believe it's on page 58 of our opening brief. And so respectfully...
Not your I'm talking about your brief. I'm talking about trial.
No, I think it's referenced there, just for your reference. At trial, the issue was that defendants were trying to break down elements into such minute parts, that we had to give a combinations and selections or arrangements instruction in the instance that the jury was believed that these elements could not be used creatively. You can have a descending chromatic scale. No one owns that. But if it's used in an original way, meaning not copied and modicum of creativity, you afford a copyright protection. Let me give you another example.
I'll ask you another question. With respect to inverse ratio, the court did not give that instruction, and you argued when the court failed to give it that that was a problematic omission.
Right.
But you didn't make that argument with respect to what you now call your combination instruction. Why not?
I think that we did make the argument for inverse ratio. The issue with the inverse ratio was that the Ninth Circuit does follow the inverse ratio.
I know you made the argument. I don't think you quite understood.
I'm sorry.
You're not listening
Here's the
to
question. When it came up and the judge said, okay, here's a set of instructions, omitted from those instructions were at least two things that you would have liked. One, the inverse ratio rule, and you said to the judge, this should have been included, and there's colloquy about that. And there were other things where you disagreed with the judge's instructions. But on what you now claim is so central to your case, this combination, you didn't say to the judge, well, wait, that's a significant instruction that's been omitted. It's like the inverse ratio rule because it undoes our case. And why didn't you make that argument?
I believe that was preserved, and I can...
That's not my question.
We did make the argument.
Did you make the argument while the instructions were being put out?
No, because we were told not to.
But if you were told not to, why did you make all the other arguments that you made about inverse ratio rule and claiming inaccuracies in the wording and that sort of thing, but then you left out what you're now arguing to us is your most central?
No, I believe that's perhaps a misrepresentation. If we review page 58 of our brief, I think that it does identify and clarify that issue. I think, am I out of time?
You are.
I'm out of time.
Thank you, counsel.
Thank you.
The case just started to be submitted for decision and will be in recess for the morning.